Good afternoon. Welcome to Grace and Gavel, where truth meets compassion. My name is Buffy. I'm an almost 18-year criminal defense attorney, and we'll be providing legal analysis. Today, we're talking about why eyewitness identifications feel certain and still fail. I want you to imagine something for a moment. Imagine that you are a member of a jury. You've listened to testimony for days, maybe even weeks. And just before you're sent into the jury room to deliberate, the judge gives you one final instruction. This instruction is about eyewitness testimony, not commentary, not opinion, not psychology. This is the actual guidance courts give jurors when deciding how much weight to give eyewitness identification. And it exists for a reason. So the judge would say to you, you have heard testimony of eyewitness identification. In deciding how much weight to give to this testimony, you may consider the various factors mentioned in these instructions concerning credibility of witnesses. In addition to these factors, in evaluating eyewitness identification testimony, you may also consider the following. First, the capacity and opportunity of the eyewitness to observe the suspect based upon the length of time for observation and the conditions at the time of observation, including lighting and distance. Second, whether the identification was the product of the eyewitness's own recollection or was the result of subsequent influence or suggestiveness. Third, any inconsistent identifications made by the eyewitness. Fourth, the witness's familiarity with the subject identified. Fifth, the strength of earlier and later identifications. Sixth, lapses of time between the event and the identifications. And seventh, the totality of circumstances surrounding the eyewitness's identification. It is within the trial court's sound discretion to instruct a jury on both eyewitness identification and general witness credibility. The need for heightened jury instruction should correlate with the amount of corroborative evidence. United States versus Masterson in 1976, the Ninth Circuit. The Ninth Circuit has approved the giving of a comprehensive eyewitness jury instruction, at least when the district court has determined that proffered expert witness testimony regarding eyewitness identification should be excluded. United States versus Hicks, that was in the Ninth Circuit in 1996, overruled on other grounds, and then United States versus W.R. Grace, also in the Ninth Circuit in 2008. Eyewitness testimony often feels powerful. It feels like they've caught someone, right? Or that the person has actually seen them and is going to be able to ID them effortlessly. When someone says, I know what I saw, we instinctively trust it because it sounds confident. It sounds without doubt. Confidence sounds like truth. But the legal system knows something important. Certainty does not always equal accuracy. Not because people lie, not because people are trying to avoid the truth or cause someone innocent to be found guilty of it because they have a, axe to grind with that person, right? And so that's why courts instruct jurors to evaluate conditions, not confidence. So jury instructions explain simply. Jurors are told to consider several factors when evaluating eyewitness investigation or identification, and we went over those. First, the opportunity to observe. Was it dark outside or was it light outside? Was it raining? Was it snowing? What was the visibility like? How far away was the person that you saw? How far away were you from the person that you saw? Are you sure that that was the person that you saw? How long were you able to observe that person? Because context matters. We talked about the lighting conditions. How far away were they? Second, whether the identification came from the witness's own memory or were they given suggestions. Maybe when they went to the police station, maybe they were given a lineup. A big thing about the lineup is the lineup cannot essentially point out certain people to potentially flag them. For instance, the people that are given in the lineup have to also be substantially similar, right? So if you know that the suspect likely has facial hair, all of the gentlemen should have facial hair, right? If you know that the gentleman was an African American, then You need to have people who look similar to them, not just pointing out certain people that look different. Things have to be uniform and similar, or else essentially you're communicating without directly communicating that this is the person that I want you to find. This is the person who is the suspect. And that would cause an issue with the fairness of the lineup. So the other thing too is, influence would be a big one. I mean, you wouldn't want to influence people by conversations or suggestions. I'm really not going to tell you like who the suspect is, but I mean, if you look at the one that's wearing the blue shirt, like you'll likely find him, right? That would be a suggestion. Or going into identification procedures, right? Because clearly that would give an unfair advantage to the person who was being singled out. Third, whether there were inconsistencies in earlier or later identifications. Fourth, whether the witness was familiar with the person. Yes, I bought a car from him at one point in time, right? I mean, that would be a stronger identification. Or whether this was a stranger. If this was a stranger, then clearly you might not be as familiar with that person. Fifth, the strength of the identification over time. Does this person continue to say, yes, it was this person? I have no doubt in my mind that it was this person. Or are they saying, well, I don't know, because these two guys look very similar. And I'm not really sure 100%. I mean, I thought it was this guy, but now I think that it was this guy. That would not be a strong eyewitness identification. And it's not just about how confident the witness sounds in court. Sixth, how much time has passed between the event and the identification? Meaning, did they see this person like over a year ago? Or did they see them as recently as a couple weeks ago, right? And finally, jurors are instructed to consider the totality of the circumstances. For instance, maybe the height, maybe considering the lighting, maybe considering whether or not they heard this person speak, maybe what this person was wearing. Does their identification match with what they feel that they've seen or what they believe that they've seen? The key point, let's talk about what jurors are not instructed to rely on. They are not told to trust their confidence, right? Hey, I said this once and I'm going to stick with it no matter what. No, that would clearly be a miscarriage of justice. They are not told that sincerity equals accuracy. No, they're told to tell the truth. They are sworn in to tell the truth. They are told to evaluate conditions because conditions can change things, right? If it's dark outside, did you have your glasses? Do you use corrective lenses or do you use glasses? Do you have trouble seeing? Do you have trouble hearing? How far away? Are you 20/20 or are you 20/25? Like what is your eyesight? Do you have trouble hearing? Things like that. Do you have any other impairments that could potentially cause your identification to be called into question? And also, let's talk about the fact that context matters. This is where eyewitness testimony often goes wrong in public understanding. Not all eyewitnesses experience events the same way. A victim in a frightening, high-stress situation may be completely sincere and still mistaken. For instance, if they are the person, let's say that this is a robbery case, right? And this person actually ran across the defendant holding a weapon at them. What is going to be the main point that they're looking at? They're probably looking down the barrel of the gun, wondering if they are going to get shot, right? And when you have traumatic incidences like that, the last thing you're really thinking of is, oh my goodness, let me stare at this gentleman who is holding a gun at my face, and he may or may not pull the trigger. And no, I need to study his features. No, that person is likely trying to not get shot. They're also probably likely not trying to be obvious about trying to see the features of the individual that is holding a gun at them, right? And pointing a gun at them, in fact. And also a victim in frightening high-stress situations, again, I mean, they can forget some of the details. They can get a little bit confused. There can be kind of a post-traumatic kind of stress kind of thing, especially high-stakes situation where someone is pointing a gun at you, right? So fear narrows your attention. You're trying to survive in that moment. You're like in fight or flight, likely. Stress fragments memories, and a lot of those memories take some time to actually come back and gel back or actually reveal what you remember seeing at that time. Because memory being fragmented means you're getting little pieces at a time. It's not coming to you fast and quickly. The brain prioritizes survival, not detail. By contrast, let's say that the gentleman said, "Excuse me, I need to get through here." And so you see him, you're more likely to be able to describe him accurately, right? Because he was polite. He wasn't pointing a gun at you. He was pleasant. So you had no reason to say, "Oh yeah, I've seen that gentleman. Yeah, I've seen him." Right? Because that bystander saw a calm, non-threatening encounter. And so they may have had more time to observe, less fear. Why would they be afraid? The person said, "Excuse me, I just got to get through here," right? Fewer distractions, even if that witness sounds less confident later. Ironically, the witnesses who feel most certain are often the ones whose memories were formed under the most stressful conditions. What the courts recognize. Appellate courts have long acknowledged these risks, meaning they know that they're inherent. They know that some people are going to be under stress. Some people have better memories. I mean, you take the person as you find them. You take the witness as you find them. But ultimately, telling the truth is very important. So in cases like United States versus Hicks, courts recognize that eyewitness identifications are especially susceptible to suggestion. I mean, especially if you have a person who is known as a police officer or a detective and they're grilling you, you literally are going to maybe potentially in fear think that you need to agree with everything that they're saying to you. And so that would not be a very good way to identify someone because you're not really helping them out. You're agreeing with everything they're saying, which may or may not be true, right? So you're not really doing yourself a favor and you're not really being honest in your testifying, as well as stress. And then also as distortion because, memories can fade, especially when you're further removed. Like as time goes by, things become harder to remember sometimes, especially given age and other stuff. And this doesn't mean eyewitness testimony is excluded. It means it must be carefully scrutinized, right? To make sure that it is fair, that it is honest, that it is an accurate description. Later cases clarified procedural issues, but the core concern remains the same. The legal system knows that the memory is fallible, especially with being removed with time, even when witnesses are honest. And I tend to believe that it's probably rare that someone would actually go in and try to essentially be dishonest and try to get someone convicted for something. I'm not saying that it doesn't happen because I'm sure that it does, but I don't think it happens as regularly as some people think that it might. So let's talk about the disconnect in the courtroom. Here's the problem. Juries are human. They respond to stories. They trust confidence. But the law asks jurors to do something harder, to slow down, to question certainty. Has this person been certain the entire time, or have they said that they can't decide between one of three defendants? Right? Which one was actually the one that committed the crime? And to evaluate how memory was formed, not just how strongly it's held. That gap is where wrongful convictions can happen without anyone lying, cheating, or acting in bad faith. Because I do think most jurors go into it wanting to be honest, wanting to give someone a fair trial, because they probably think of the consequences of what would happen if they were in that spot and didn't get a fair trial. The takeaway: eyewitness testimony doesn't fail because people are dishonest. It fails when confidence is mistaken for reliability and context is ignored. That's why jury instructions exist, and that's why eyewitness evidence must be handled with care. Because memory isn't recording, it's a reconstruction. So in closing, when you hear an eyewitness say, "I know what I saw," the real legal question isn't sincerity or truth or whether they believe what they're saying. It's whether the conditions under that memory was formed allow it to be reliable. And that distinction matters deeply in the pursuit of justice. Thank you for tuning in to Grace and Gavel, where truth meets compassion. Thank you so much for tuning in, and I hope you'll come back and see us again soon. Have a great day. Bye-bye.